While legalizing marijuana as a matter of federal law would take an act of Congress, President Obama can decriminalize it. He can do this by moving it out of Schedule I of the Controlled Substances Act, which is reserved for substances that have no medical purpose and have a high potential of abuse, and therefore have high criminal penalties attached to their mere possession. Virtually all marijuana-related arrests are handled by state and local law enforcement. The Federal Drug Enforcement Agency, or DEA, simply lacks the resources to enforce the federal ban across all 50 states. That's why the Justice Department decided not to fight the legalization of marijuana in the handful of states that have taken that step. President Obama, without rewriting any laws or stepping outside his constitutional authority, can direct the Attorney General to start the process of reclassifying marijuana as a Schedule IV or V substance, or declassifying it altogether. Reclassifying marijuana as a Schedule III substance or lower would have significant benefits for the budding marijuana industry and individual users. For example, the Internal Revenue Code prohibits the deduction of business expenses that relate to Schedule I or Schedule II trafficking. The Gun Control Act of 1968 prevents the sale of ammunition and firearms to the unlawful users of any controlled substance. A conviction for possessing a controlled substance can bar students from getting loans. And the rules are even stricter for public housing. Declassifying marijuana would solve all of these problems, but even merely reclassifying it would make it easier for legal businesses to access the full economy and reduce violent crime. Marijuana deregulation sits squarely within the control of the executive. The president should use his executive powers to allow for intelligent enforcement of drug policy without eroding the rule of law.